Good morning, sir.
Good morning, namaskar, namaskar, you all people.
Sir, we welcome you to Indian Law Institute virtually, and we are very excited that, sir, you will be teaching us the practical aspects of IP, which the students here were actually very eagerly awaiting for the same. So, for the students, sir is the DP IIT chair at IIT Guwahati, and sir has been in practice since, sir, how many years?
I started in 2005 in CSIR IP unit.
Okay, sir. So, we'll start with the lecture, sir.
Yes, sir.
Thank you so much, sir, for accepting our invitation.
Welcome. It's actually privilege to serve you people at ILI, Indian Law Institute. I earlier visited also ILI for such session. So it's all about practical aspects. So I believe you all know the basics of such IPR, particularly patent, design, trademarks. So please feel free to ask any questions in the field of practical aspects of all such things, like how to proceed filing application for such IPR, what is the minimum requirement. So I will try my best to cover all such things within the stipulated timeline. So let's see. Sharing option. Hopefully you got the screen. Yes. So I don't know whether a screen is visible and which screen is visible there, because there are so many screens. Okay, so close. So I start from a patent, and this is the patent portal, ipindia.gov.in. Okay, so anyone can create the account here, but it's only the patent agent who can file this application online on behalf of the client. Otherwise, your applicant, the client, can file it directly with their own login. There is some issues in sound. I think there is some echo. Okay. So once you start the filing kind of things, this is the first window you can see. If your invention is based on any research oblique information, I feel difficulties in the sound because it's a echo all the time. Just give me. Okay. So you can see, particularly in the field of bioresource, whenever we file such application, we need to take prior approval from National Biodiversity Authority. Okay, so this is the general pop-up we received all the times filing any application, whether it's from the field of bioscience or chemical science or physical science. So we always ignore this message by proceed to e-filing without going NBA website. Many times we don't have bioresource based invention. Maybe it's a chemical, maybe it's a mechanical other physical kind of invention. Even if it's a bioresource based invention, we no need to bother going at this moment to NBA website for that prior approval. Okay, we can submit it anytime before the acceptance of our patent application. And after requesting this prior approval from NBA, National Biodiversity Authority, they have to dispose our such application within 90 days. So even at the time of acceptance of our application, Patent Office will not going to issue the patent certificate until unless we arrange the NBA approval to them. So we can submit this NBA approval at that moment, so that after disposal of this NBA approval, patent certificate may be issued. So next step would be proceed to e-filing, not to go to NBA website. Now, whenever we say patent application, there are 9 different types of patent application. Okay, so this is international patent application. If already filed, then we can enter in member countries as a national phase application for patent. So we have to enter here PCT/year/ the serial number for that international application. So at this moment we discuss a general patent application. So see all the forms 1 to 31. I think this is visible there. 1 to 31 left side. These are some shortcut. So new application, whenever we go filing a fresh application, new application, all the times proceed to e-filing, we have to select. Then jurisdiction, automatically it will decide as per the address of the applicant. So we have 4 patent office: Delhi, Mumbai, Calcutta, Chennai, 4 metros. Type of application, see different types of application: conventional, divisional ordinary, divisional PCT, ordinary, patent of edition for ordinary application, for conventional application, for PCT national phase application, and national phase application. These are total 9 different types of patent application. Generally, whenever we talk about patent application, then that means it's an ordinary application. In common language, we never use this word ordinary or some other words like conventional or divisional or edition. All the times we use the word patent application. Mostly it's an ordinary application. So what next? If you select this ordinary application, then again we have 2 options: provisional and complete. What does it mean? As name indicates, provisional, that means even if our invention is not complete, we can proceed with provisional application. So there is no much requirement of description, claim, examples, data. We can complete it within 12 months. So there is no further requirement of government fee at the time of filing, complete after provisional. If like we can proceed directly with the complete application without filing the provisional one, but there is no any harm in filing provisional, and there is some benefits that we can enjoy the priority, so that if anyone filing application in between provisional to complete, their application will not be treated in view of your provisional application. And that's why it's always suggested that no need to wait for your invention completion. You can proceed even before the completion, so that you can have 12-month grace period. More interestingly, if people need more time, even after 12 months, they can request for extension of time before expiry of 12 months, so that in the same application, provisional one, they can file the complete without additional fee, and they can enjoy the priority. Now we have to enter number of pages, like how many pages for the description of your invention. See, patent office don't ask you the prototype or the real product, real invention. They are not asking you to visit their patent office, or neither the patent officer visit your place. Everything is online. So they need the documents. You need to write your invention in digital form. So that is called patent specification. So it's a patent specification, and that have different components like this: description, claim, abstract, drawing, sequence listing in case there is a bio invention. So it depends case to case. So there are various components: field of invention, title of the invention, background of the invention, objective of the invention, utility of the invention. So we have to write here number of page, number of claim, number of page for abstract, number of page for drawing, how many drawings, number of drawings, all such things we have to enter. Because the government fee decided based on the number of page of that specification and number of claim. So in general government fee, only 30 page for the description and up to 10 claim are considered. If we exceed more than 30 page or more than 10 claims, there are some additional fee. Most of the times we received hardly 10 to 20 page for patent specification, and there is hardly more than 10 claims. So there is hardly much requirement to arrange government fee for additional page or additional claim. Sometimes there are some additional page and additional claim, and there is no any limit for such number of page or number of claim, because the client need to pay additionally for such extra pages, extra claim. So there is no any restriction. Even there is no any restrictions regarding number of applicant for that application or number of inventor in that application. So there is no any limit regarding numbers. Now, title of invention we have to enter. Let's see, we filing here a dummy application, complete application. Okay, so number of description, suppose it's a 20 page. Number of claim, suppose it's a 10 claim. Number of claim, suppose 10, and it's a 2 page in which all 10 claims are covered. Abstract 1 page, drawing, number of page, suppose 4 page, and every page have 2 drawings, suppose 8 drawings. There is no sequence listing. So title of invention, so if you like you can suggest any title, like can you suggest any drone? Mobility, you can suggest any title. Title must be within 15 words. Yes, if anyone want to interact. So address for service, that so address for service must be an Indian address. And there is some echo. So whenever there is any application file in any of the country, actually I feel disturbed because there is some echo. Okay, I will divert my. Hello, whether I'm audible?
Yes, sir. Yes.
Okay.
Yes, sir.
Okay. So address for service. Address for service must be the address of that same country where application has been filed. And see, all the time such applications are territorial in nature. What do you mean by territorial in nature? Such patent, design, trademarks, GI, you can claim by filing such application in particular country. So you have to file in number of countries where you want to exclude others, not to.
Someone asking, sir.
Whether there is any message in chat box.
They are saying
So if there will be any questions, I will turn it on again
Okay.
accordingly.
Okay. Okay. So for address for service, all the times we need a national address. So suppose someone filing here in India from US. So they need some Indian patent agent, and address for service must be an Indian address. See the scope for career opportunities. All the times, all the countries are very much interested in Indian market. So all the times we receive numerous applications all over the world here in India, and all the times all such applicants need to hire some Indian patent agent, because address for service must be an Indian address, and so that patent agent address can be used as the address for service. So suppose the address is ILI, New Delhi, pin code. Now state, it's Delhi. Mobile number, it's a compulsory requirement to give one mobile number, because nowadays there is a notification given by IP office. A telephone number, it's not compulsory. If you like, you can mention. Similarly for fax number, not a compulsory requirement. All the times we need to mention at least one contact number, mobile number, and one email ID. So alternate email ID we can mention. Abstract. Now we need to provide abstract for that invention. That abstract must be within 150 words. Like title must be within 15 words and abstract must be within 150 words. So we have to highlight what is the novelty and inventiveness of that invention and the use of that invention in this abstract. So we have to write the abstract in 150 words. Now we have to write description of the invention. So again, there is no any limit regarding number of words, but it's up to 30 page we can cover under the description part. Otherwise we have to pay little bit extra fee for government fee. So suppose this is the description part, and now the claim part. We will discuss all such things later on also. So we have to copy paste here abstract, description, claim. So we have to arrange one invention disclosure in the particular prescribed form, that is called patent specification. We have to copy paste all such information like abstract, description, claim here on the portal. Now we have to add applicant. Suppose applicant is who can be the applicant? Now see the option. ILI, Indian Law Institute, may be one of the applicant. Another, your supervisor, faculty may be the applicant. They can apply. Third, you people, the participant, a student, might be you got some idea, you worked on such idea, you invented something useful for the society, you may be the applicant. The agent is not the applicant. Agent is applying such patent application on behalf of the applicant, and applicant may be you, your faculty, your institution. Okay, so it depends the gender. If it's a legal entity like institution, then we have to select other. Most of the time in institutional system, applicant is only the institute, not the staff or students. So research scholar, faculties, these are not considered the applicant in case of institution, institutional innovation. So most probably there is some question in your mind that it's the individual natural person who may conceive some idea, who may start working on such idea. So it's the natural person only who can invent, who can be author, who can be the designer, who can be the photographer, isn't it? And legal entity like institution, whether it's IIT or ILI, they can't create anything. It's the people only inside such institution who can create, innovate something. So why applicant in such cases, institutional cases, is the institute only, not the individuals like you people. Now, if applicant is filing such applications, the question arises, what is the proof that they have ownership? How to prove such invention? The ownership of such invention is with ILI or IIT. How to prove? So all the time in such institutional cases, the applicant, that is the institute, need to arrange proof of rights. That applicant, that institute has proof of right that they have rights to apply for patent, they have inventorship. So what is this proof of right? So all the times they required signature of all the inventors. In that case, that these inventors are the true inventor for this invention, and they are assigning their such rights to that applicant, and by virtue of such assignment, that institute can claim proof of rights. They have rights to apply for patent. Hopefully you got this concept, proof of rights and inventorship, how applicants can institute can apply for patent under the applicant category, and we people like inventors, maybe the students, research scholar and faculties are excluded from the applicant. So this is just like a property invention, so it can be transferred. Inventor name can't be transferred. If you are the inventor, all the times you will be the inventor. So there is a column for inventors too, other than applicant, and all the times all the inventor's name will be there. So no need to worry if your name is not mentioned in the category of applicant. So applicant and inventor, these are two different things. Inventor may be the applicant, all the applicant may not be the inventor. So it depends case to case. Now see applicant type. There are 5 different types of applicant. Natural person, that is you people, your faculty. Other than natural person, a small entity like MSME, micro, small, medium enterprises having Udyam Aadhar, a startup. These are the companies which are recognized by DPIIT. They have a startup certificate. Educational institution, those educational institutions which have recognition from the government. So all the times these people need to arrange one supporting document. Like a small entity need to arrange Udyam Aadhar, a startup need to arrange DPIIT, a startup certificate, educational institution need to arrange certificate from the government body that these are recognized under so and so. So we have to select for this ILI. I am selecting this educational institution. Now applicant name, Indian Law Institute. Nationality, so it's not we people only, it's the organization also, they have nationality India. Now again the address of ILI, so we can put ILI New Delhi and pin code. We can use pin code here. There is no any compulsory requirement to enter like telephone number, fax number, but we have to arrange email also. So we can arrange the email like most of the time we use professional email ID, because if we use institutional email ID or applicant or inventor's email ID, if they receive any communication from patent office, they are unable to comprehend sometime. So they are unable to follow up, they are unable to understand what next, what to do, and that's why such patent professionals use their own email ID. So rather than using their email ID, we are using our own email ID. Now country, again India. So they have database. Whenever we mention any data here, all such data entered in their database. So state, again the Delhi. District, I'm not sure the district, so let's see. New Delhi, oh yeah, this one. Now city, city is the New Delhi. Although this is not compulsory, we can ignore the city. Add. So this applicant information is added in their software. Now if you want to add multiple applicants, you can add further applicants, like in some case MOUs, joint venture, multiple entities collaborated to invent something. We can add further applicants. So see, one applicant is added here. Type EI for educational institution. Gender, it's neither male or female. Other category, name of the institute, nationality, address, pin code, STD, phone, fax, email ID, country, state, district, city. We can edit, we can remove it, we can add. I suggest you people, whenever you try such things, don't try to edit it. File a fresh application, fresh form all the times. Don't try to edit whenever you need any such requirement to amend, revise the document, because this portal is not perfect. Whenever you do such edit, all the times you will face problem later on. So don't do it. Now if inventors, suppose there is a inventor name, like you people, if you are the inventor, if your name is there as the applicant, so your name will be the inventor. So applicant and inventor in that case will be the same if inventor is filing the application as the applicant. But in such institutional case where institute has filed such application as the applicant, institute can't be the inventor. So we can't select this. Inventor are same as applicant. If inventor name is there as the applicant, we can select inventor's name. So inventor's name can be copied here also in the column inventor. But ILI is not the inventor, so we have to remove it. So it's the applicant who is the ILI, and in such case, inventor's name we have to add inventors. So now I am adding the inventor. So it's Dr. Pranit. Email ID is not compulsory requirement, but if inventor is interested to get notification from IP office, they can use their email ID. Now the country, India. State, we can ignore. If there are multiple inventors, we can add further inventors, like add inventor. So first inventor name is there, so we can add and number of inventors. So there is no any limitations regarding adding the number of applicant, number of inventors. We can add it. Now there are some declaration. First one, we can't select it. Okay, the provisional specification relating to the invention is filed with this application. Since we are filing complete application and it's not the provisional, so we can't select it. Now the second, complete specification relating to the invention is filed with this application. So we are filing the complete application. So this is selected default. This is already selected there. So we are in possession of the above mentioned invention. So this is default. So it implied that if you are filing this application for patent, you possess this invention legally. Next is invention as disclosed in the specification use the biomaterial from India. If your invention is based on biomaterial, we can select it. If it's not based on biomaterial from India, we no need to select it. So ignore. Next, no lawful ground for objection to the grant of the patent. So it's already selected. We can't change it. That means if you don't have such possession of the invention, if you don't have lawful ground of objection to the grant, then you can't file this application. That's why already these are selected. We can't change such selection. Now next is I or we are the assignee or legal representative to true first inventor. So in this case, who is filing? This is institute, ILI. So ILI need to declare that ILI is the assignee or legal representative of the true and first inventor, where inventor are you people, individuals. So we have to select it in that case. But in case the inventor is filing the application as the applicant, in that case we no need to select this one, assignee or legal representative. So we have to be careful when we have to select it, when we no need to select it. Now next is application or each of the application particulars of which are given in para 5 was the first application in convention country. So in case the application is already filed in any of the member countries under conventional arrangement, that is under Paris Convention. So there are more than 200 countries are the member of the convention country. India is one of the countries. So such member country can enter in any of such member countries within 12 months. But this case is ordinary application, not the conventional application. So we no need to select it. Next is we claim the priority from the above mentioned application. So in case application is already filed in any of such member countries, then we can claim the priority. We are not filing here conventional application, so we no need to claim priority, so we no need to select it. Now last three declaration, these are not applicable in this present case, which is the ordinary patent application. So we can't either select or deselect. Lastly, these are some shortcuts: Form 9, Form 18 and Form 28. So what is Form 9? Form 9 is for request for early publication. So if you request for early publication, you have to pay again the government fee. This is not the compulsory requirement, so we can ignore it. If we ignoring, our such patent application will publish after expiry of 18 months. So we have to wait for 18 months. And if we need prior faster mode, expedite processes, then we have to request for publication, because there is no any examination of such filed application without such publication. So if we need early disposal of such application, there is a requirement of examination, and to initiate the examination we have to request for early publication. Although this is optional, but to dispose the case faster, we have to request Form 9. Form 18, that is for request for examination. So again there are two options. Like in case of publication, there are two options. One is optional. So even we don't request, our application will automatically published after expiry of 18 months. And another option, we can file Form 9 so that our application may publish within 1 month. Similarly, in case of examination, there are again two options. One is normal examination and another is expedited examination. So for normal examination, the fee, form number 18, there is a government fee, and for expedite, there is a form number 18A, and again the fee will be doubled than the normal fee. What are the fee? So all the time fee depends who are the applicant. So as per the nature of the applicant, whether the small entity or individual or startup or MSME or educational institution, fee may vary. So we will discuss regarding the fee. And this form 28, this will applicable only for educational institution. So not education, it's for the requirement for the applicant. If they want benefits for a startup or MSME or educational institution, they have to upload the supporting document. Like in case of a startup, the supporting document would be the DPIIT startup certificate. Similarly, in case of MSME, under Form 28, we need to upload Udyam Aadhaar. Similarly, in case of educational institution, we need to upload documents for recognition of such educational institution on form number 28. What next? So, proof of right, power of attorney, priority document, etc. are required to be submitted in original. So, this is only document which we need to submit patent office by post, original document. Rest all such document need to be arranged by this portal, online portal. We have to upload all such document, and in fact all these documents like proof of right, power of attorney, priority document, also we can upload online. No need to send such document to patent office. If they ask to submit such original document, then only we have to submit. This is the general practice nowadays. So it's almost 100% online. No need to submit even such original document which is mentioned here, like proof of right, power of attorney, priority document. All the times we need to submit it online only, not the hard copy, until unless they ask such document. What next? Do you want the application to be filed under SIPP scheme? So there is a government scheme to promote a startup. So only the facilitator who are enrolled in this scheme, they can give benefits to such applicants under this SIPP scheme, where patent office directly reimburse the professional charges to such professional who enroll under SIPP scheme, and in order to get such benefits they have to select yes. If these are not eligible for SIPP scheme, or the practitioner is not enrolled in SIPP scheme, in such case they have to select no, because ILI is not eligible for SIPP scheme because it's not the startup, it's the educational institution. So we have to select no. Lastly, I agree that above information submitted by me is true to my best knowledge. Now we have to select save. File is saving. Wait, now see, your form has been saved. An email verification link has been sent to your email. So we can check our this form online anytime after this message. Next step is to upload the document. So this is the data entry kind of things, where we have entered the basic information like abstract description, claim, number of pages, type of application, title of invention, address for service, our email ID, contact number, such declaration, name of applicant, name of inventor, all such things. Now see form history. There is a drafted form. Now see first one. This is drone mobility. Form number 1. Email not verified. So email is that email is I think not working because I mentions I think ILI one. So or might be you got some email from IP India to verify it. We can do preview. See the preview. So form 1 under the Patent Act 1970, under the rule 2003, application for grant of patent, name of the applicant, name of the inventor, title of the invention, address for correspondence, priority particulars, PCT. So this is not the case of priority particulars. So this is not for 5, 6, 7, 8. We have to ignore all such paragraph. Lastly, declaration. Now see declaration by the inventor. This is considered 9(1) as the proof of right. So all the times this form 1 mention all the name of inventor. See declaration by the inventor. 9 declaration first point 1 declaration by the inventor. I/V so and so, all the name of the inventor is mentioned here. Is/R are the true and first inventor for this invention, and declare that the applicant herein is are my or our assignee or legal representative. Date, signature of the inventor, and name of the inventor. That means all such people like you, a student or research scholar, or the mentor, guides, faculties, innovator, inventors, all such people whose name is there, they are giving such declaration that applicant is the assignee in such case with your date and signature. So that will be used by the applicant like institute, maybe it's ILI or any other institution, as proof of right. So this is the concept of proof of right, that such legal entity who are not the real inventor can file application for patent without mentioning your name, individual's name in the column applicant. So you are the inventor, your name will be there always in the column inventor. So some people sometime add inventor's name in the applicant also to motivate. But see, what is the difference in inventor and applicant? Applicants are the owner. Inventors may be the owner, may not be. Inventors always need to get recognized, and that's why there is a compulsory requirement to disclose the name of inventor. So there is a one message, will inventor also need a proof of right? No, inventor no need to arrange proof of right, only in case they are suppose for inventor, and once they file application and they mentions multiple name in the column applicant. So even if single name additional to name of inventor, in that case all the inventor need to assign their interest collectively in the name of all the name of applicants collectively, so that that additional person who is not the inventor may have that proof of right. If inventors and applicant are common, all the inventors who are the applicant also, there is no any additional name, in that case there is no any requirement for such proof of right. So either we arrange signature on this form 1 or we can arrange a separate document, that is assignment document. So generally we avoid such assignment document in such case. It's a relatively much easier to get signed on this form number 1 only, where all the name of inventor is mentioned. Next is we can ignore this case because this is the ordinary case and it's not under conventional arrangement. if suppose this application files as a conventional application, so we have to arrange signature of all the inventors here only, not in this 9.1 but 9.2. Again, lastly, 9.3 declaration by the applicant. So earlier it's the declaration by the inventor, and this one is declaration by the applicant, that is institute. So institutional authorities like either the director or to whom director assigns such authority on behalf of the institute, so that for the purpose of patenting, that person can declare, can sign such document. So these are the declaration, like complete specification relating to the invention is filed with the application. This is in possession of above mentioned invention, no lawful ground of objections, and we are the assignee or legal representative. Lastly, following are the attachment with the application. So we have to attach multiple documents here. The minimum documents which we need to attach along with this form number 1. And this is form number 2 only. So minimum documents which we required, form number 1 and form number 2. What is form number 1? Application form for patent. And form number 2, that is complete a specification or a specification, whether it's a provisional case or complete one. In both the times we have to use the specification. What is a specification? The disclosure of invention in a prescribed format. A specification may be a provisional one, a specification may be a complete one. So as per the kind of application, whether application is provisional application, then a specification will be provisional specification. If application is complete application, then a specification will be complete specification. So date of submission and signature of the applicant, or on behalf of the applicant, the name of agent. So agent can sign if they have proof of power of attorney. So if we are filing the application with the help of some agent, we have to arrange power of attorney in the name of that patent agent. That power of attorney we need to arrange to patent office, either the soft copy or hard copy, within 3 months. If we exceed more than 3 months, then we have to request with petition. So we have to pay extra for petition fee. So this is minimum requirement, form number 1, form number 2, and this power of attorney. So these are minimum requirement at the time of filing. Other than these documents, we have to arrange more documents which we will discuss. Now we can take it as a print, save as PDF. We can save it. So desktop, this is form number 1 for ILI. Now see this form. I'm not sure whether screen is visible. This form, I don't think I shared the screen. Whether screen is visible? No. Okay. So just a moment. I miss. Okay, so we can see the preview, and we can download this preview PDF file. Okay, now we can upload. Do you want to proceed? Yes. See the form history, again drafted form. We can select. Actually this email is not verified, that's why we unable to upload it. I'm not sure which email ID I have mentioned there. Or just a moment, I'm checking. The email ID I mentioned IPRP Kumar. Okay, got it. Yes, I received notification from IP India. Now that email ID is verified successfully. So we can upload the documents here. Now see the list of documents which we can upload at this moment after preparing form number 1. We can upload form number 1, the same form which we saved PDF after entering all the data like applicant name, inventor's name, address. Next is provisional specification. If this is the case of provisional application, but this was filed as the complete one, so we have to submit this complete specification. So we have to choose the file. Suppose this is the file form number 1. Similarly, we can upload the documents for a specification if it's a complete specification. Just imagine this is the CS complete specification where all the information is mentioned in the document. We can submit it. Similarly, we can upload more documents like drawing. In case there is a drawing, we can upload similarly. In proof of right, we have to arrange signature on form number 1, and after getting signature on form number 1, we have to upload that signed form number 1. Here we can upload. We can submit this form number 1 after getting signature from all the inventors within 6 months. So these are the timeline. Power of attorney within 3 months, proof of right within 6 months. If we exceed the time, then there is a penalty required. We have to request for condonation of delay with the petition or with extension of time, and for that there is a prescribed form and prescribed fee. All the time such fee depends on case of the applicant. For a small entity including educational institution, a startup and MSME, the government fee for filing the application is 1600, only 1600 rupees. 1600. Next step is early publication. The cost is 2500 rupees. 1600 plus 2500. And third step, examination. The government fee is 4000. So if we include all these 3 steps, the total government fee would be 8100. And the fee for large entity, it's a 5 times. So they have to pay 8000 for government fee for filing the application, 12,500 for early publication, 20,000 for request for examination. So it's 80% discount to a small entity including educational institution, a startup, MSME. So what next? Drawings, forms, evidence for registration, sequence listing, priority document, translation of priority document, statement and undertaking. We have to submit this form 3 within 6 months. Like if we file some application, based on this application anywhere in this world, we have to arrange the information like date of filing, name of the country, application number, what is the current status of that application. So all such foreign filing detail we need to arrange on this statement of undertaking on form number 3. If we unable to submit somehow such form 3, again we have to request for petition for condonation of delay or extension of time along with prescribed form and prescribed fee. So we have to be very much careful regarding all such forms, the deadline, otherwise there is a penal requirement. Power of attorney, if we are filing with the help of patent agent, declaration of inventorship. So where inventors are not the applicant, in that case applicant need to declare who are the inventor. So in that case there is a requirement to submit form number 5. So these are the documents which we need for the filing. In case there is a requirement to give figures in abstract, then we can upload a separate figure for that abstract. So these are the documents. Once we upload all such document, there is a digital signature. Hopefully it's visible to you. It's a DSC. So either we use DSC or we can use e-sign. Proceed to sign document. So it asking form 1. So let's see. We can upload this form 1 again. Now we can proceed to sign document. Drawing. Can you remember at the time we filing this application, we entered the data for page, for the drawing and 8 number of drawings, and that's why it's asking where is the drawing. If we didn't mention such data there, it will not ask to upload the drawing. Since we already mentioned there is a drawing, there are some page, there are some numbers, that's why it's asking upload the drawing. Now we uploaded one dummy page. So now these are the options to sign the document. So you no need to print the document, sign manually, scan it and re-upload it, no need. Now we can use either DSC or e-sign. If you use e-sign, you get OTP on your mobile, or with the help of that device we can do e-signing. What next? Once we submit it, there is a payment portal like this, payment submission. Make payment. Your application will be mentioned here. You have to select it and pay. As soon you pay it, there is a receipt. On that receipt you will find the application number. So there is a number. First 4 digit will be the year. Next digit is type of application. Next digit is for the patent office, whether it's for Delhi, Mumbai, Calcutta, Chennai. So there is a number 1, 2, 3, 4. 1 for Delhi, 2 for Mumbai, 3 for Calcutta, 4 for Chennai. And rest number are serial number. If we didn't submit form 9, that is for early publication, form 18, that is for examination, we can submit it later on. So with the help of that application number, like just see random application number, I don't think it will take. So it needs a real application number. So let's wait. I am arranging one application number. So this is one of the application number which I already filed form number 9. Let's see what it says. So form 9 is already drafted. Please check your drafted form. So it's true. I already submitted form 9. It's not only form 9. We already submitted form 18. So it will not take a fresh request for form 9 or form 18 because all such steps already disposed. Form 9 already uploaded, disposed, it's already published. Form 18 already done. Examination report we received. we have to reply the examination report within 6 months. Earlier the timeline was 12 months. So we uploaded the reply. So what next? Next is patent office will re-examine the reply to their objection. So this is called FER, first examination report. That means there may be a subsequent examination report, second examination report, there may be hearing. So patent office will dispose such application based on merit, and without hearing they can't dispose it. So before taking any adverse action, there is always an opportunity to be heard. So either the applicant, the inventors, or the agent on behalf of such applicants or inventor can attend such hearing. All such hearings are online. So if you like to attend offline hearing, you have to mention at the time of replying the examination report that in case there is a hearing, you will prefer online hearing or offline hearing. So mostly we people prefer online hearing only. So with the help of application number, you can track the status all the times, like whether this is visible, another portal where we can access the status, like before you apply, public search. Can you show me whether what is the screen? Whether I can change the page or we have to check the status. No, I can't change. Okay, this is the only portal where we can see, just like PNR, we can check the current status of our tickets, isn't it? Similarly, you can check the current status with the help of this application number, like this application number. You can check. Where we can check? This is ipindia.gov.in. The same portal you can find the status. You can check the status any moment. So what is the status? You can check. What next? You have filed the application got published. If you requested, then within 1 month, every Friday they publish it. Next step is request for examination. So after requesting examination, they will issue the examination report, which we need to reply within 6 months. After that, they re-examine, and based on the case to case, they may either issue a new examination report, or they may issue a hearing schedule, or they may directly issue the certificate based on the merit of the application and the reply to such examination report. They can consider and issue the certificate. There are some cases where all such things dispose within 6 months, and within 6 months they have issued patent certificate. There are some cases where more than 6 years are awaited to get such certificate, and forget certificate to dispose such matter. Dispose means either the acceptance of such application or rejection of such application. So this is all about the patenting process. Once application is granted, we have to renew it. So see, renewal of patent. So this is patent number. So far we discuss application number. Once patent granted, we get patent number. This number is different than application number. Now we have to pay for renewal of such granted patent. First 2 years is free. From 3rd year onwards, we have to pay renewal fee. So suppose if the patent is granted within 6 months or 1 year, we no need to pay even for 2nd year. We have to pay renewal only from 3rd year. But in case where application is granted in 10 years, it may take 10 years to dispose. Then just after disposal, within 3 months, we have to pay 10 minus 2. First 2 years are free. So we have to pay for 8 years. Otherwise, our such application will get abandoned. So reply to examination report. Once we have examination report, we have to reply. Uh, we have to upload all such documents. So already I replied it. So I don't think it's asking. So we can upload multiple documents. If we need some revision or amendments, we can resubmit such document like FAR response. If we can submit application number, okay. So this is the application number. This is the date of filing, 12th February 2024. Type of application, applicant, that is SC, a small a startup entity. Title of invention, method for producing a quantum dot nanocrystalline and lubricate monolayer of molybdenum disulfide. So this is a chemical invention, and particularly it's a method for producing a chemical substance. So invention, what can be invention? Invention can be a product, invention can be a process, can be a method, can be a technology. So address for service, see, address for service is an Indian address. Name of applicant, this is the name of applicant. See, there is a repetition, it's a twice. Why it's a twice? We have to check. And applicant name along with the a startup name, that is Hardai Armed Engineering Solution. They have added inventors too in the applicant, like Ramphal Rajiram Sharma, engineer Devesh Ramphal Upadhyay. So they have added inventors too in the column applicant. Next is applicant address. So see, address for service and applicant address is same in this case, but most of the times we see address of service is the agent address, patent agent address or patent facilitator or IP attorney address. Case to case it may vary. Now see, in case of hearing, so please confirm your preferred mode of attending the hearing, either video conferencing or since this is filed by patent agent, so there is no any option other than video conferencing. If such application filed directly by such individuals or applicants, so there no need to give power of attorney to the agent, and all such hearings they have options, either they can attend it online or offline, but patent agent can't attend such hearing offline. And for the purpose of filing, professionals can't file offline. All the times they have to file applications online only. It's only the applicant, if they want to submit such application offline, they can submit it offline. Government discouraging offline application, so they required to pay 10% extra government fee if they are filing it offline mode. So this is all about the patenting step by step. But most important, in such patent practice, we have to be very, very careful regarding what are things which can be considered for patent, what is not patentable. If we don't evaluate such subjects before filing, will be total waste of time, energy, resources if we filing such things which is not considered patentable. So before filing, we have to analyze all such things, and that is called patentability analysis. For the purpose of patentability analysis, we required prior art search. We have to check it, what is already in public domain. So there are some criteria for patent. First criteria is novelty. Such invention must be new. If such thing is already in public domain, we can't establish the novelty. So all such efforts will go waste if we are unable to justify the novelty requirement. Similarly, the second criteria, inventiveness. So there must be at least one inventive step. There may be multiple inventive steps, So our invention must be different than existing one in view of the novelty and inventiveness. So there must be some value addition or economic significance so that we can justify our invention is new and it is either more economical than the existing one or having technologically advanced than earlier one, so that we can justify inventiveness also for our invention. Otherwise, whatever we file, everything will be accepted by that online portal. They will never object. You have to pay a government fee, and whatever you submit, all such things got published. So there is no any requirement like plagiarism. You can do anything, copy paste here. There is hardly any human interface which review your filed application, and everything goes published after either expiry of 18 months, or if we request for early publication, generally within 1 month all such things got published. We can't consider such publication like research publication. So we have to give weightage only to those applications who got disposed positively by grant, because it's only those applications who fulfill all such criteria like novelty, inventiveness may be considered for grant. Rest applications which are not patentable can't be considered for patent grant. So what next? You have to check prior art, you have to check patentability aspects of such filed application. We have to wait for publication, we have to request for examination, we have to do the examination report within 36 months. If we don't request for examination within 36 months, our such application will may be abandoned in lack of prosecution. So in case if we miss such a request for examination, we can request with form number 4 for extension of time, and we have to pay government fee for delay of every month. So every month we have to pay penalty for such delay, and max to max up to 6 months we can extend such time. So better we have to comply all such requirement in time in order to avoid such additional government fee, additional formalities. So this is all about the patent. And regarding the drafting, what is the complete specification or specification? So there is a techno-legal drafting, how to disclose your invention. So there are some components. I suggest you all people, you must refer some patent specification, how to get such patent specification. So there are different options you can get patent specification. You can try Google patents. What is Google patent? This is not your search engine, Google search. You can type google.com/patents. Now see, now feel the experience. It's not the Google search engine, but it's a advanced patent database where once you use any keywords on that patent, google.com/patents, you will find all the hits for patent document. There is not a single citation, single document which is not a patent literature there. If you check that hits, you will find all such hits are patent document. So check the parts of all such documents. You will see there are different parts like title of the application invention, field of the invention, background of the invention, detailed description of the invention, brief description of the invention, examples, application of the invention, claims of the invention, abstract of the invention, drawing of the invention. All such things you will find in all such documents. So we have to arrange all such information. So being a law student, most of the times we are not much aware about such technology. So we can help in documentation, we can do follow-up, we can do patent litigations, but for the purpose of filing such application and appearing before the patent officers or in patent office, there is a requirement to pass the patent agent examination, and the minimum education required for that patent agent examination is science graduate. So we can help in other IPR matter. We can do service in patent matter too, like renewal, litigation, opposition, rectification. So there are n number of steps where we can provide our services even in patenting without having science qualification. And most of the times you will realize later that this is a teamwork. So individual practitioners, it's very difficult to serve all such things for individuals. So all the times we need a team. So we can arrange all such compliance timely. So if you have any questions in the field of patent, please feel free to ask, or we can move to trademarks and design. So relatively designs and trademark filing is more easier because there is no much requirement to submit any such written document, a specification. There is hardly any such steps like publication, request for examination, nothing. So that's relatively much easier. So So if you have any question in the field of patent, please feel free to ask. Otherwise, can I move to trademarks or design?
Sir, I think there's a question in the messages.
Okay, let me see. Are there other source for literature search? Yes, there are so many. Every country maintain government database for such patent literature, like India using INPAS, Indian Patent Database. Similarly, all the countries like US having USPTO, European countries have SpaceNet, and there is an international database under WIPO, World Intellectual Property Organization, named Patent Scope. So we can check any of such database, and most of the times all such database which I mentioned, these are free. So anyone can use such free database. There are some paid database also that have to be subscribed, and yearly fee would be more than 3 lakh per user to check such database. And these are like STN, Dialog, Derwent, Orbit. There are so many paid database. But most of the times, in order to use such database, we need some skills how to use such database. So without having such skills, there is hardly any benefits using such advanced level database. I suggest at least we can use Patent Scope and this googlepatent.com/patents, so that most of the applications you can find here on such database free of cost. So you no need to bother any language barrier here, because all such things you can find English translation here. And what is sequence listing? See, mostly in case of biological inventions like sequence of RNA or DNA or protein sequence, we need to disclose what is the list of such sequence, either for protein or RNA, DNA. So all the times this is not the requirement. It depends case to case.
Sir, what principles should we keep in mind when formulating the claims, so there's a higher chance of grant?
Very good question. So otherwise, I must escape this question. So claim, this is the key, which is considered for patent. Maybe single claim, maybe n number of claim. So rest part of the specification, which may run in thousands of pages, that are not considered for patent. This is just for the supporting document, supporting information what we are claiming. So such claim must be not so vague or so broad that we can cover almost everything under such claim, and such claim must not be so narrow that we can exclude what we need to claim, otherwise no one interested to get license or assignment from such patent holders. So this is very critical, what to cover, what not to cover. So that's the beauty of drafting such patent claim. Otherwise, even there are so many patent, but in view of poor drafting, they are unable to commercialize such patent. So if we are interested for technology transfer or commercialization, we have to be very focused what need to be claimed. If we miss some important things to get claim, might be our invention got patented, but we can't enforce it because no one bother to get license or assignment, and they can commercialize such patented invention because this is poorly drafted. What we need to claim not mentions in the claim part, so this is disclaimed. We can't restrict others not to commercialize such patented invention. So there are so many patents which granted, but due to poor drafting we are unable to commercialize. So this is only by practice we can draft such a specification, and all the times it's a field of invention. So we have around 21 field of invention. So all the times the controller, the examiners are particularly from a particular field of invention, so that whenever they receive such patent application, they can understand it as per the field. Otherwise, no one can serve in all the field of technology, all the field of inventions. So once you file the application, you can, once you check it, once you search it, you realize there are so many different kinds of subjects, and all the times it's the practice only we can understand the patent specification, we can draft the patent specification. And that's why I request you, please must go through that claim part. You will realize sometimes people have only single claim, sometimes they have more than 20 claims, sometimes such claim run in hardly one line, and sometimes single claim may run in 2 pages. So just enjoy the way people writing the claim. So based on your keywords, you can find the applications, the claim. So you can enjoy such claims in different field of invention.
Thank you, sir. Thank you so much.
So there is a number of classes we required for patent drafting, patent searching. So we can't cover all such patent drafting, searching here. So better you get exposure of such patent document, patent claims, so that you can understand what kind of things which can be covered, how they are writing such things. So shall I move on trademarks or design?
Yes, sir.
Okay. I think you got this design portal. On the same ipindia.gov.in, you can find all such links for patent, design, trademark, copyright, GI. So this is for design. So with the help of password or with the help of DSC, you can log in it. Now this is the design portal, where you can have options like quick form filing, all forms, new application, form 15, form 16, miscellaneous form. Again similarly like patent, form history, payment or submission, all such things. You can select new application. So this is the class. We have total 32 class here in design. Under Locarno agreement, Internationally, all the member countries have to follow such classification code. India is a member country, and so we have to follow such classification code. So once you file any industrial design application, you have to arrange what is the class for that article. All the times such designs we are filing that are implemented on certain article, but we are not claiming the article itself, but the aesthetic appeal of that article. And that aesthetic appeal, that is the design part, look part of such article, that are classified under such classification. So we have to select such class like for clothing items is class number 2, for textile, artificial or natural sheet it's a class 5, household good it's a class number 7, clock or watches class number 10, article of adornment, so maybe jewelry items may be covered under this class number 11. So we have to select the article, now the type of application. So again, these are two types, ordinary and convention. If we didn't file such application outside India and first time we entered here in India, then the application is considered ordinary. And if someone filing it from outside India already filed in their countries like US, UK, China, and entering here in India, then the application will be considered conventional application. So just assume that the application filed by you people, so it will be considered ordinary. Again, your name, suppose it's Agricultural University Jodhpur, applicant address applicant country India. So these are some basic details, all the times we have to enter. So you can realize what are the actual requirement at the time of filing such application, whether patent, design or trademarks. These are the actual requirement. State, so it's a Rajasthan for Jodhpur. Nationality India again. Now if there are multiple applicant, so I already added one applicant, Agricultural University Jodhpur. If there are multiple applicant, we can add here. So we are not going to add here multiple applicant. Suppose it's only one applicant. Most of the cases applicant is only one. There may be n number of applicant if there is a joint venture, joint project, multiple article. Now we have to add article. So article name might be this is agricultural tool, some agricultural tool. Most of the times all such tools have certain name, like agricultural planner. Planner here is to make field plain. So since I already selected class 11, that is for jewelry items, and that's why the subclass is it's showing in that field only. So better we have to select it jewelry some jewelry like suppose ear jewelry or neck jewelry. So whether it's a trinket or medal, badge, artificial flower, fruit, plants, flags, festive decoration. If you find the relevant one, then it's okay. Otherwise, you can select miscellaneous. So I am selecting miscellaneous here. So this is ordinary case, so we no need to arrange more information because there is no such information, priority country, priority application number. So just add it. Now see article added. Article name is ear jewelry. The class. Next is applicant type. Again, who is the applicant? Whether natural person, other than natural person, a small entity, or a startup. So in your case, either your institute or your name will be there. Sometimes institutional startups, so they can mention their startup name also. So in your case, I am mentioning your name. So address for natural person, previously registered class, so it's not registered previously. Again, address for service will be ILI, New Delhi. Email address for communication, so it's IP dot. Computed fee. So for a small entity, the government fee is 1,000 rupees. For education, natural person, so it's a natural person, a small entity, a small entity and a startup, all such have government fee 1,000. If we select other than natural person like ILI, ILI is not a natural person, not a small entity, not a startup. So the category would be other than natural person, and in that case the government fee would be 1,000 rupees. So just check it, select other than natural person. Now see the fee 4,000. So in case of a small entity, the fee is 1,000, and for other than natural person, the fee would be 4,000. Now we have to declare applicant claim to be the proprietor of the design, and that to the best of his knowledge and belief the design is new or original. So can you find the difference in patent and design here? In case of patent, means here applicant need to arrange proof of right. But in case of design, ILI is not a natural person. Other than natural person, we already mentioned regarding the type of applicant, and that person, unlike patent, not required to arrange proof of right. But in the same scenario, in case of patent, that need to arrange proof of right from the inventors. So they need inventor's signature. But in case of design, they no need to arrange inventor signature. They have to disclose only this declaration that the applicant claim to be proprietor of the design, and that to the best of his knowledge and belief the design is new or original. So this is the criteria for design: novelty and originality. Now we have to save this form. So we can see preview of this form. Just like patent, we can see the preview. This is the preview. Form number 1, application for registration of design. In case of patent, form 1 is for application for registration of patent. In case of form 1 in patent, there is a title of invention, name of the applicant, name of the inventor. But in case of design, we can see rather than title of invention, there is a title of article, like article, ear jewelry, class, subclass, name of the applicant. There is no any name of designer here. Since there is no any name of designer like inventor in case of patent, and that's why all the designers' name are added in the column applicants. So all the designers along with the institutional name covered in the name of applicant, along with the institute, their name are added as the inventors. So all the designers are mentioned here in the name along with the applicant. So address for service, email ID, mobile number. So we can save this document for design. This is form number 1. Form 1 design ILI. Now see, we have to upload the documents. Either directly we can upload it here, but most of the time it will not work. So better go to form history, see the option form 24, other document, power of attorney, priority document, representation sheets, and form 1. So mandatory documents are these two, representation sheets and Form 1. We have to compare all the time such things with patent so that we have better understanding what is the key difference, what are the common features, what are uncommon features. So like in patent, we have to upload minimum documents, Form 1, Form 2, Form 1 for application for patent and Form 2 for patent specification. Similarly in design, these are two minimum requirements. Form 1, that is application for design, and Form 2, rather than Form 2, there is a representation sheet. In case of patent, Form 2 is for patent specification, and in case of design, the second form, that is representation sheet, that you need to represent your article, your design. You have to mention the views of the article under that design. Suppose the article is ear jewelry, so you have to arrange different views of ear jewelry under that document, that is called representation sheet. So you have to arrange views like top view, bottom view, side view, lateral view, perspective view. You can arrange n number of views. So it depends how many views required. Might be two-dimensional, so only one single view is sufficient. Sometimes we required multiple views. So we have to upload that document called representation sheet and form number 1. So how to upload? We can refer this drafted form. This is the form number 1 for Indian Law Institute, the applicant not a natural person. So there is no 80% discount here for industrial design. Unlike patent, educational institute are considered for 80% discount, but no such discount given for industrial design. So we have to upload the documents here. Minimum documents, form number 1, you have to select this form, upload it. Next is representation sheet. Just imagine the same form is a representation sheet. You can upload such a representation sheet. Now you can proceed to sign the document. So again you will get two options, DSC and e-sign. Now you have to select it and sign the document. You will get these two options, either DSC or e-sign. Once you sign the document ready to get payment. Once you pay it, there is a receipt. In that receipt you will find the name of the article, date of the filing, application number, and again based on the application number, just like PNR, you can check the present status. So there is no any request required for publication or examination. So in one go all such things will be processed. You will get examination report. You have to reply it within 3 months from the date of filing. So there is hardly much time required to get design application disposed. At least you will receive the examination report within 2 to 3 months. And once you reply the document, that examination report, next step is maybe hearing or subsequent office action. So this is regarding the filing things. This is miscellaneous form, where once you receive the examination report, you can upload the reply here, a reply to FER, first examination report. Again, if there is a hearing, we have to submit post hearing submission in writing, like hearing submission. Similarly, we have to upload post hearing submission in patent case also. So this is all about the portal, how to upload such document, what are the minimum documents, what are different kinds of documents which we need to use in such online portal. Now, if you have any questions, then we can discuss it. Otherwise, we can proceed for trademark. So recently portal got updated. Yes.
So we can directly move to trademarks and take question at the end,
Okay.
cumulatively for both the countries.
Okay. So, hopefully you may find this trademark portal where you can sign it. Okay. So you will get notification and reminder for your earlier applications which you already filed. So you can see the notification and reminder where you need to take action. Otherwise, in lack of prosecution, your earlier application will get abandoned. So right now I'm having 5 notification and 10 reminders. So at least 5 applications I need to take action as on now. So new form filing. Okay, I have to check it, otherwise I can't proceed for new filing. So these are some of the examination report. There are 5 application numbers. See 1, 2, 3, 4, 5. There are some examination report. All the times all such applications I received examination report. These are the date of examination report, and we can see the notice what objections mentions in such examination report. So I have to do mark all so that I can continue with e-filing. Without reading all such 5, I can't continue with e-filing. So all notifications have been marked and read successfully. Now we can file new form. So this is the form number 1, that is TMA, like design trademarks. This form, that is TMA, we need to file for the purpose of filing application for trademarks. So we have to select applicant. Like patent and design, there are options like individual, a startup, MSME, educational institution. Similarly, there are different kinds of applicant here: individual or sole proprietor, a startup, a small enterprise, and other. So there is no any concept educational institution here like design or unlike patent. So suppose ILI, they have their logo, their name. If you want to proceed for trademark for that logo or the word mark can be anything. So it's not individual, it's not a startup, it's not a small enterprise. So it will be considered under other category. So what next? See, there are different kinds of application. Like in patent, there are 9 different kind of applications. Similarly, more than 9 type of application you can find here. So in this case, the ordinary application will be considered a trademark application. It is not a conventional application because it is not already filed in some member countries. It's not a multi-class application. It's not a certification mark, not a collective mark. So these are different kinds of mark. Now based on the class, we have to file. There are total 45 class. As per the number of class, the government fee will multiply. So for one class, the government fee will be 4,500, and for large entity, it's 9,000 rupees. So for educational institution that are also considered as a large category, so government fee will be 9,000 rupees. So if we have some documents like Udyam Aadhaar, we can treat such educational institution in a small enterprise. So government fee will be reduced to 4,500. Otherwise, we have to pay 9,000 rupees. So number of class, if there is multiple class, we have to multiply such government fee with number of class. Suppose there are 2 class or 10 class, so we have to multiply such government fee whether 4,500 or 9,000 into 2 or 10. So what would be the class for such applicant, business or services? So ILI trades provides services, not the manufactured item. So these are considered for service mark. All service mark are trademark, but all trademark are not service mark. So educational services are considered under class 41. I believe it's a class 41. So once you submit it, then there is a temporary application number. This is a temporary application number. There is a class. Nature of application is the trademark. You can add proprietor name like ILI, category, whether it's a single firm, partnership firm, limited liability, joint firm, joint applicant, HUF, government department, body incorporate, association of persons, society, trust. So we can consider it like it's neither the association of person nor body incorporate. It's a government department we can consider. So address again ILI Delhi. We have to provide full address. India, state not specified. So we have to mention state, district again. Hopefully it's New Delhi. Email ID again we have to mention some email ID, phone number, legal status. Government recognized educational institute. Now we have to submit it. Required proprietor. So we have added the applicant. Now the applicant agent. So if applicant is not filing this from their own portal with the help of facilitator or the agent or attorney, if they are filing, then applicant agent detail will be there. So it's from my login, so my information is there. So we can change the address. We can add multiple address. So there are multiple address. Most of the time some people are interested to give their own address, so we have to arrange their address only. Either I can use my address or on request of them we can arrange their address also. So either I can arrange this address, Delhi one. There is hardly any offline communication, so there is hardly any document received on such address nowadays. We can add our advocate number also. There is no any compulsory requirement, so we can avoid it. Category of mark. So these are the category: color, device, shape, sound, 3-dimensional word. So as per the requirement, if it's a device like logo, we can select it. Now we have to upload the device. So if you don't want to upload, better we can use the word, so that there is no any requirement to upload the image. Otherwise, if you don't select the word, then you have to upload the image. Now the word, either the ILI or the full name. So there is an option for AI based public search. We can search it whether same or similar name already applied there or not. So you have to declare whether you have searched it or not. So you can check it, you can search, you can tick it yes. Now condition or limitation, you can ignore it if you don't want to restrict your claim. So we can claim such words, such mark all over India. So there is no any condition that you are restricted such rights only in Delhi or NCR. There may be your sister concern in anywhere in the country after some time. So there may be some franchisee or some sister concern here in Northeast. So no need to condition or limitation regarding your marks. You can mention goods or service description here in class 41. So we have to write it educational services. So there is a nice classification. As per the nice classification, we have to check the description for such goods or service under that particular class, because most of the times we receive objections that this is not as per the nice classification. So either class is wrong or what we are claiming such description under that particular class, that is outside the scope of that class. So we have to refer that nice classification before filing such application. So next is a statement as to use of mark, whether we are proposing to use that mark or whether we are already using such mark. So old is gold. All the times there is a weightage if we are already using such mark since long. So there is a problem in patent and design or requirement in patent and design novelty. Such applications must fulfill the requirement of novelty, but in trademark case, there is no such requirement to prove novelty. In fact, if there is no novelty, if it's already well known, so it's easier to get trademark registration. So in this ILI case, we have to select, we already using it since last 20 years or more than that. So we have to mention a particular date like 1st January 2010 suppose. So we have to mention the date, month, year. Any other important information we can ignore it. Now we can save and resume. So you can see the preview. Similarly, patent preview, design preview, this is a trademark preview. This is from TMA, Trademark Act 1999, application for registration of trademark. Temporary reference number so and so, nature of application, this is a trademark application, applicant filed as other, government fee would be 9,000 rupees. Applicant, there is only one applicant here, name of the applicant is ILI, the address is ILI Delhi, country India, jurisdiction Delhi. So we have 5 trademark registry, Delhi, Mumbai, Calcutta, Chennai and Ahmedabad. So your case will fall in Delhi trademark registry jurisdiction. Address for service, we can update this address for service as per the requirement. Mobile number, email ID. So these are marked data here because there are so many frivolous agents in society who do follow up with the applicants, and that's why on the request of applicants and the professionals they are masking such mobile number, email ID. Nature of the applicant, so whether it's a startup, educational institution, government department. Legal status, applicant agent detail, category of mark, whether it's word or logo or device, what is the word if any, ILI, image description, if there is an image then we have to describe that image here. Language, whether it's English or in some other language. Conditions or limitation if any, we didn't limited our such claim for such trademark. Particular for class it's 41 and description of that class is educational service. And this is for a statement as to use of mark, that the mark is used by the applicant or its predecessor in title since 1st January 2010 in respect of goods and service mentioned in the application. So in order to claim such prior user, we have to arrange some supporting documents, some evidence on affidavit. So this requirement will be not required if we don't claim such prior use. If we claim propose to use, then there is no such requirement. But using such a statement, it's relatively much easier to get positive disposal of such application. So we can again print it to save it. This is TMAILI. So we have saved 3 application document, patent, design and trademark online. Now we can upload the documents like this form 1 or TMA, and once we sign it digitally or e-sign, we can upload the government fee, and as soon we pay the government fee, there is a receipt like patent and design. Yes. So if you have any question, please feel free to ask. I know most of the times we have practice of PPT presentation, so we don't feel such experience filing such applications online on the portal. So it's so simple. Within this time period, we have filed 3 applications: 1 patent application, 1 design application, 1 trademark application. You can pay. As soon you pay, you will get the receipt, and all the times in that receipt there is an application number. Based on that application number, just like PNR, you can check the current status all the time. You can download all the documents exchanged between the agent, the applicant and the IP office, whether it's a patent office, trademark office or design office. Similarly in case of copyright and GI. So everything is online. All such things is transparent. Any person interested can access all such documents online without any cost. So my focus is only on such practical aspects, how to use such database, how to enter such data on such online portal. I know there are so many queries, but it's due to paucity of time, might we be unable to dispose all such things. I'm here, so if time permit, you can ask. So sir, if you could guide us how to register ourselves as trademark attorney. Okay, so I noted you all are LLM students. So LLB is enough. So once you qualified AIBE exam, All India Bar Council exam, you can register yourself as a trademark attorney. So without qualifying trademark attorney examination, you no need to qualify that patent trademark attorney examination or design agent examination like patent agent or any other examination. You can do practice filing such design application, trademark application, copyright application, GI application. That All India Bar Council examination is enough. Once you have that certificate of qualifying that exam, you can enroll as a trademark attorney, copyright attorney, GI attorney or design attorney. No, you no need to be a trademark agent or design agent. You will be considered attorney, not the agent. Those who are not the advocate, they can qualify that trademark agent exam, isn't it? So you no need to qualify any further examination. That LLB is sufficient. You just have to pass your All India Bar Council exam, arranging the advocate certificate. That is enough to start such practice. Any of you can file such applications online. How to generate the attorney code? Just try creating your login account on trademark portal. I tried it long back in 2010. So might be there is some changes on the portal, I'm not sure. So just hit and try. Every people are generating their attorney code from that portal, and once you successfully file first applications, you will get the attorney code. Next time, all the times you will use that same attorney code. If there is any problem, you can start first application offline. So once you submit your offline application, you will get intimation from the trademark registry, and in that intimation you will find your attorney code. So if you generate it online, well and good. Otherwise, you can initiate your first application offline also. patent agent examination, if any of you have science graduate qualification, UG in any of the science field, either chemistry, physics, bio, or any of such basic science or technology, then you may qualify for patent agent examination. And for that patent agent examination, there is a two-stage examination. You have to have some skills for drafting the specification. So there are options. Either you can draft one bio or chemical applications, or one physical applications like mechanical. So there are different options given to you at the time of examination. You have to do some practice how to draft such patent specification in your field. So they are, as per the field of inventions, they are different officers, different person, same patent agent, same patent controller, same patent examiner can't serve in all such different field of invention. Again, there is a Bayer Act. All the times, you know, trademark act, patent act, copyright act, you have to review, you have to study that patent act, and you can review last 10 years question paper on patent portal, what kind of questions generally they ask in such patent agent examination. So you need practice. Without practice, it's too difficult to pass such patent agent examination. So if any of you want to serve me, either in the capacity of volunteer or intern, you can connect. And there are so many connections. I may try for placement. So be in touch. If someone who having science qualification want to join us here in IIT Guwahati, you are welcome. So you can do it either offline or online. So my contact information you can access from the authority there. In fact, I used my email ID and contact number on such filings during patent, design, trademark applications. So if you notice, you can find my email ID and contact number there. So any further question?
Thank you so much, sir, for accepting our invitation. And I think in the matter of 2 hours, you have covered patents, designs, and trademarks. Sir, it would not have been really possible without your support. And sir, we wish to see you at ILI campus also whenever you are in Delhi.
Certainly.
And hopefully, these people will be really interested in working with you because they are very good researchers.
Most
Sir,
welcome.
I'll send you their profiles. Yes, sir, I'll send you their profiles and everything. So, sir, we will work together on this.
Thank you
so
very much.
sir.
Thank you for your patience hearing. Thank you.